Honestly, I never thought I would be having a HIPAA conversation with a lawyer for a marketing publication, but here we are. If you haven't heard, there's been a recent ruling by the Texas courts that basically upheld the American Hospital Association's challenge to OCR's guidance on HIPAA and whether or not the organizations can use third-party tracking tools on their website. I'm about to sit down with my friend Matt Fisher, who is a lawyer specializing in healthcare, to ask him some questions about the implications of this ruling and what was in that legal brief. I'm excited for you to hear what Matt has to say. Let's get to it. Matt, welcome back to the program.
Yeah, no, happy to be back. I think there's always evergreen topics for us to talk about, and who would have thought that one of those options would be tracking technology?
There you go. And who would have thought we would really enjoy having lawyers on a marketing, a video and a marketing podcast? It's always fun to have you on, Matt.
Yeah, no, thank you. I know in the past it's been more fun, especially when I was paired with Jared at one of the conferences, and he rapped and provided the actual entertainment.
That will go down in history as one of my favorite moments, by the way, when you you two were up there and he was rapping and you were there. Well, I would like to think that you were up there beatboxing, but hey, like it was awesome.
I will allow the imagination to run wild in whatever direction you want it to go after the fact.
Oh, well, that's awesome. Well, today, Matt, I wanted to get you on because, of course, we had this momentous ruling that happened in Texas around the HIPAA and third-party tracking technologies that, has been such a change to the way healthcare marketers have to work. And just quickly, for those who don't remember, back in 2022, some guidance came out that basically said that hospitals can no longer use these third-party tracking tools because it was a HIPAA violation, because the combination of the IP address plus whatever that person was doing on the website could be considered or was considered PHI. So things like retargeting vanished overnight. You couldn't do that anymore. And using Google Analytics and Meta's and Facebook's Pixel to track things was no longer possible because of this ruling. But of course, that ruling was challenged by the American Hospital Association, and the courts in Texas came up with a ruling. So, Matt, my first question to you is, can you boil down what the AHA was actually asking for in terms of their challenge to that ruling by ONC or that guidance from ONC?
Sure. So, kind of like the challenge that the AHA made towards OCR's guidance was, kind of, as you pointed out, around what the court in the decision ended up defining as the prescribed combination. And that combination was combining an IP address with information about a visitor going to an unauthorized public website, or UPW. And kind of, I'll use some of these terms because this is how the court wrote about it, which most likely came out of how the AHA and OCR briefed the issue when it got teed up to the court. But it was, again, combining the IP address with information gleaned from a visitor going to that unauthorized public website, or UPW, that had information about a health condition or healthcare provider. So, OCR was trying to take the position that when you combine that information, that would constitute individually identifiable health information. And then if you have IIHI, because we love acronyms in healthcare, if you have IIHI relating to a past, present, or future healthcare condition or payment for services, that then becomes protected health information, or PHI. So kind of the AHA, when it brought the suit challenging the guidance, said that that was an overstepping of the bounds by OCR and how you can interpret IIHI, because to a large degree, this was kind of the first time OCR was taking such a clear statement around this type of information that's generated through the operation of different forms of technology. So it wasn't challenging the entire guidance or document, that bulletin that came out, because a lot of it honestly was just a reminder of what entities need to do to comply with HIPAA, which is, if you're kind of boils down to, if you're going to share PHI with a third party entity that's providing you a service, they're a business associate, have a BAA in place and take the appropriate steps to comply. But it was really kind of focusing on this broader point. And I know, kind of as you gave in that brief summary of how we got here, that can be where a lot of the valuable marketing information can be gleaned from. So it was focused in on that kind of arguably small piece, or what amounted to a sentence or two within the guidance document, but ended up having this really broad impact because hopefully, as people picked up from how I described it, it was a very broad sweeping statement.
So for our marketing audience, Matt, can you summarize what the ruling is or was?
Sure. So it can really be boiled down to a really short, simple piece to understand, which is essentially the court removed that statement from the guidance. It removed that, as I said, what it called the prescribed combination, said that has been vacated, meaning it can't be enforced, and it's needs to be taken out of that guidance document. So you kind of remove that, where OCR said that combination of information, again, the IP address and the visit to a UPW that has information about a condition or provider, and said that comes out. Kind of the other piece of it that allowed the court to get there was saying that the guidance on that front did create a new legal obligation and new burdens on covered entities in terms of what they would need to do to comply with that statement. So, it's kind of the first piece was the court saying, yes, there's actually an issue for us, the court, to decide. And then the actual operative decision was to remove it. And actually, if you go to OCR's website now and pull up that guidance bulletin, it actually does have a disclaimer in italics at the beginning of the document saying, per the decision, the court in this case, we've taken this part of the guidance out. Earlier in 2024, I think it was in the March timeframe, OCR had actually revised that bulletin, and it introduced the subjectivity component to the analysis, which, kind of in my view, was really much ado about nothing, because how can you ever know exactly what a visitor to a website is thinking and intending to do with the information they're gleaning from it? And the court kind of focused in on that as well, essentially saying it's impossible to know. And if you read what OCR wrote, it said, just to be safe, you should treat everything as PHI and protected and subject to HIPAA, which essentially kind of subverted the introduction of that subjective component to it. But what that subjective component was, OCR said, well, if someone does go to that website and it's just for research, or it's just to get general information, it doesn't actually relate to any treatment or condition that they have, yeah, then that's not PHI. But again, how can an operator of a website know that without getting into each individual user's head, which, at least to my understanding of technology, is impossible at this point in time? Maybe when we get, the brain implantable chip that Tesla is trying to create, maybe we'll have a different outcome there. But, for all intents and purposes now, you're not going to know that. So as I said, the court kind of said it saw through that charade and said, no, you created this new obligation. You're saying this is what you have to do to comply. And that you kind of took it a step too far, because you can't know if that information actually relates to an individual, and if it relates to their a healthcare condition or service that they're seeking. So as it kind of parsed through it, the court said the interpretation in the bulletin was inconsistent with the plain language of the definition of IAHI, and that's why the court took it out.
So the bottom line here, first of all, thank you, Matt, for that description. So does this mean that hospitals and healthcare organizations can go back to the way things were? Can they go back to using like these third-party tracking tools and going back to using retargeting and everything now that portion of the guidance has been vacated?
Yeah, so one, I think if you recall from our first discussion, we said you could always use the technology, on a blanketly without worrying about it, if that, whoever was producing the technology was going to be willing to sign a BAA and comply with all the attendant requirements of HIPAA. That's obviously the easiest way to get to it. And by easy, I mean, from a compliance perspective, easy, because you're then hitting it, and you don't have to worry about where you're placing that tracking technology, whether it's on the UPW side or an authenticated portion of the website, because again, that's still going to be an important distinction. You know, as I said, I'm using easy in connection with compliance because I know from an actual operational standpoint, using the, like the Google Analytics tools or Metapixel, those are the easier options because they're likely more readily deployable. Maybe they cost less because they are, generally applicable across industries. So, to really get to your question, it again is going to depend on where you're deploying the technology. So let's take it to the clear answer. If you're going to put it like in the patient portal or somewhere where the user has to log in, you still cannot use this technology. Like that's not what the decision or the challenge focused on. Like it wasn't my impression that anyone was disputing that once you're behind a login and it's clear that the information you're gathering relates to someone seeking services or care of a provider, that's going to be PHI and HIPAA applies. If you're looking at just the general informational pages on, say, a hospital's website that are outside of that, then this decision will help you kind of use that more publicly available technology in the way that it had been used. You're still going to have to be careful though to understand exactly what information is being collected and in what combinations being collected, because again the guidance and then the challenge is focused on that prescribed combination. If you have other information involved, then you're still going to want to go through an analysis to determine, is this additional information putting us more clearly into a zone where it qualifies as PHI, or is it still so anonymous that it would require that, knowing the intent or some other unknowable aspect to get it into that identifiable realm that we can feel comfortable that it's truly unidentifiable information that you don't need a HIPAA compliant tool for. So kind of the quick answer in summary is yes, I think it has allowed going back to how things used to be to some degree, but there is still kind of that wake up call that was provided that it's necessary to not just blindly deploy and implement technology without understanding what's actually being done.
Right. No, and I like the distinction you made there. Like, if you're behind the firewall, meaning you're sorry, you have asked someone to log in, so into your portal, into some protected area of your website, that seems to be very clear that that is now PHI because you know who it is, and they're obviously on your website to do something, meaning they've been to there before, probably been a patient. So it's very likely that what they're searching for is related to their personal health, and so that combination clearly is IHI and therefore subject to the HIPAA. Subject to the protections that you don't want to be shipping that information off to a third party that's not signed a BAA with you. But on the other side, like if you're just tracking people of what pages they're using, how long they're spending on your website, just for the sake of maybe using it for design of your website, now it seems like the ruling says that's fine. Like that's okay. That kind of tracking if you're using Google Analytics for that, go for it because that's not considered PHI, which I think most people would recognize. Yeah, that was never the intent of the law or that guidance, and that's probably an okay use of the technology.
I think that's a pretty fair summary, and it does help introduce a little bit of that common sense understanding. Again, I think where a lot of the problems arose was just the blind deployment of the technology without considering and giving weight to those distinctions.
There's one gray area I want to ask you about. And again, we're just riffing, and I know what you say is not legal opinion, but where it gets gray is if I use this technology to, let's say you're a visitor, I don't know who you are, but you're visiting a lot of smoking cessation pages on my website, right? And one of the typical retargeting campaigns that I would do is like, oh, you've shown an interest in smoking cessation. I'm going to retarget advertising to you so that when you're on Facebook or LinkedIn or any YouTube, you're suddenly going to see a lot of my smoking cessation ads to say, hey, if you're thinking about quitting smoking, here's a guidance, an infographic you can download or anything like that. To me, that's really gray because essentially, does that not mean that the hospital has assumed that that is actually what you were searching for? And now I'm serving you up an ad through this third party? Like you're basically declaring that, yeah, I think this person actually was seeking this kind of care. Therefore, isn't that PHI?
Um, I mean, I think as you said, it is creating an assumption, But on the hospital side, it is still just an assumption because it,
Mhm.
for example, I could, say I was, I don't smoke, but what if I was going to the website and I was scrolling through all that smoking cessation stuff because I wanted to pass it along to a friend who I was trying to encourage to stop smoking? Like, the hospital doesn't have any way of distinguishing if it's, a use case like that, or if it's, in this example, my friend going to the site and looking at the information for themselves. And that's kind of that subjective element that OCR had tried to introduce when it revised the bulletin, but undercut that position by saying, absent being able to actually know that intent, just treat it all, the prudent course is to just treat it all as subject to, HIPAA protections. And, again, that's what the court honed in on. So, I think the distinction there is, while that activity could invite a perception that something inappropriate is going on, again, that how you're doing it, but it's really more the follow through of what happens once you've started that targeting of, say that does trigger that user to say, oh, you know what, actually, these are services that I want to access. How is that connection then being made, and where is that connection being made? Because once they, because arguably once that person says yes and clicks and says, I want to get that treatment, now that makes it, an easy argument to say that that piece of information constitutes PHI, because as you said, their identity, and now you know that they're seeking a connection to receive future services, which is going to constitute PHI. So it's, there's, and I'm sure this well from the marketing side, there's that continuum of interaction. So, as you kind of move down the path that you're trying to create of guiding someone towards what you think is the action that you want to have happen out of it, at what point do you cross over from generalized sharing of information and unidentifiable information to identifiable information that is going to constitute PHI and require the intended compliance obligations to be followed?
I'm going to switch gears on you a little bit, Matt. I mean, this all stemmed originally from lawsuits that were started independent of OCR and independent of the AHA, where individuals were starting to sue hospitals, where the class actions were starting. What happens now to those cases now that this ruling has come out?
Yeah, I mean, it's a good question. Obviously some of those cases already settled, and I think it would be extremely hard to unwind the settlement. Also, largely because the settlement's not going to have admitted any wrongdoing. It's just going to be a settlement to have gotten rid of the case to avoid that, the cost of continuing to litigate. You know, so those are the ones that have arguably already gone away. To the extent there are cases still pending, it would seem like this is going to be offer a bit of that smoking gun to say we didn't do anything wrong, to the extent that the case is about the tracking technology being deployed just on the
Oh, yeah.
UPW side of the house. There were still a lot of allegations that a lot of these systems had deployed the tracking technology within behind authentication triggers. So to the extent that the cases still are dealing with those parts of it, this decision is going to have any impact on that. So, it really will take kind of teasing apart what are the basis of all the claims in each of the suits. It could even be that the claims are based on the deployment of tracking technology in various parts of the website. So maybe kind of a couple of the claims of the lawsuit can be dismissed, but the rest is still going to be able to continue just based on where it's alleged that the technology was being utilized.
So, is there any hope for the OCR to bring this back or to refine what they mean, or do you think they're just going to drop it now that this ruling has come out? Like, where can they go from here? In other words.
Yeah, so there's probably a few different options of where OCR could go. One would be pushing Congress to enact changes to HIPAA to arguably more clearly figure out how it wants to interact with and handle information that's flowing through different forms of technology. I think the court pointed out, and obviously this has been a frequent topic of discussion. HIPAA, the original statute was passed in '96. That is well before a lot of this technology that we're talking about existed. You had some changes from high tech in '09. Doesn't really touch on these aspects of technology, so it's there obviously have been a lot of calls for saying it's time to go through and do an update to the law and be able to capture information that's being generated through all forms of technology. So that would be one route, is OCR going to Congress and saying, hey, it's time for you to do your job, update the law. Absent that happening, OCR could examine what it can do by going through an actual formal rulemaking process. So, could either do a notice of proposed rulemaking where it puts out a bunch of questions soliciting feedback, which it can then which it could then utilize to produce a proposed rule, allow for the notice and comment on that proposed rule, and then issue the final rule. I think if it goes that route, the decision will still provide a lot of guidance, because as it was we were talking about a little bit earlier, part of what the court said is that OCR misinterpreted and tried to read the statutory definition in a kind of tortured way, is how I would say the court was nicely putting it. But that OCR was applying the terms not how they read in plain English, and was using that alleged misreading of the terms to expand the definition of IHI beyond what it really should encompass. So even if the OCR does pursue an actual rulemaking process, there's no guarantee that it would be able to get to the same place that it tried to get to through the bulletins.
So this brings up an interesting topic, Matt. I mean, HIPAA was created so long ago. The revisions in 2009 didn't really touch in these areas. Is it time to look at HIPAA? Do we need to, or is it okay the way it is? Because I got to say, having read through HIPAA, I mean, yes, I read that too. I mean, it was written in a way that you could tell the lawmakers were trying to future-proof it as much as they could, but they could not imagine a time where this information was flowing as freely as it is today. I mean, back then, like the stat was that only 20% of Americans had access to the internet, and most of them were still on modems of some sort, right? Not nearly as ubiquitous as it is today with cell phones and everything. So, but is it time to really update HIPAA?
Yeah, I mean, I would say yes, but I don't know if it's calling it HIPAA or saying that HIPAA needs an update is necessarily the right way to frame it. Because as you said, and this is definitely my perspective, I think HIPAA is very flexible, and as you said, isn't so prescriptive that it can't meet where the industry is with current technology. I think part of what has become problematic, and why I think you actually just need more comprehensive legislation dealing with privacy and security generally, is technology has expanded so much, and it's bleeds across different areas. So having very isolated and siloed privacy and security laws, of which there's really only kind of two primary federal ones. You have HIPAA for healthcare, then you have Gramm-Leach-Bliley implemented very stringent controls for the financial industry. But otherwise, you really don't have too much out there that clearly addresses privacy and security from the federal government. It's the Federal Trade Commission, through its ability to go after unfair and deceptive business practices, can get in that direction. But that's not the same as having something similar to GDPR or CCPA, where you have a very comprehensive, cohesive set of statutes and regulations. So as I said, my belief is I think we definitely need to have a federal privacy and security scheme. Having so many different states now implementing their own, makes it honestly hard to operate a business, because you're having to comply with so many different requirements that can be similar, but just different enough where you can't just necessarily have one set of compliance practices. You have to have ones that fit every single law that becomes applicable to you. And that also, I think, begins to help address the fact that a lot of the concerns around privacy of healthcare information and technology are occurring in spaces outside of what HIPAA actually covers. It's still, HIPAA still has a very broad footprint, but so many people have very intentionally designed products to stay outside of its coverage that that's where having a more consistent set of regulations would be helpful. I do think that anything that happens on that front should align with and mesh with HIPAA, because I don't think you necessarily want to wholly rip it out and replace it, because that is very hard to do. If you have if you have regulations that are this long standing and people have gotten used to operating under, not touching on the discussion of, I still also think there's rampant misunderstanding of what HIPAA actually does and how to comply with it. Trying to remove something that is arguably that ingrained within an industry is very difficult. And again, my view is it's more beneficial to try and figure out how can we mesh and build more infrastructure around that, so you have a kind of a more comprehensive and cohesive scheme overall.
Yeah, and I don't think in any of our journeys we've ever heard people argue that HIPAA shouldn't exist. I mean, I think people complain about it, but I don't think people are saying it shouldn't be there, because I think the concepts and the principles inside that law are solid. Like they're very valid, and they're there to protect the individual rights, which is great. And you shared a ton of great information with us today. Where can people go to connect with you online?
Yeah, so LinkedIn is always a great place. That seems to be one of my favorite haunts at the moment. I still am on X or Twitter or whatever you want to call it. Blogging, and then can also find me on at a new law firm that I've recently joined called Hancock Daniel. So can find me on the website there, and be able to get my firm contact information as well.
Amazing, Matt. Well, thank you so much for taking the time to come on camera and give us this little update on the ruling.
Yeah, no, it's my pleasure. It's always fun to be able to chat with you and hopefully get folks better educated on all the different laws and interpretations that impact healthcare, and definitely marketing within the industry.
Hey, I want to thank Matt for coming on camera with me and giving me his opinion on the latest ruling from the Texas courts on the OCR guidance regarding HIPAA. Now, off camera, Matt did tell me that we do have to temper our exuberance a little bit. I mean, we can't just all go rushing off to re-implement everything we had before, for a couple of reasons. One, there is still the potential for the organizations to appeal the decision, in which case it would remain in force until the appeal process is done. And also, it is really unclear in terms of the lawsuits that are still happening, because obviously this ruling doesn't prevent those lawsuits from going forward or new lawsuits from being filed. So organizations should still exercise a degree of caution and shouldn't just flip the light switches back on in terms of using third-party tracking technology. And hey, if you enjoyed this interview as much as I enjoyed being part of it, please like and subscribe. Also, head on over to Swaay.Health, that's Sway with 2 A's, .health, where you can find more great content like this. I'm Colin Hung. Thanks for being here, and I'll catch you on the next video.
So Matt, I read the ruling, and I have to say, are all legal rulings this witty? Like, there were a lot of pretty witty comments by the judge in that about being clairvoyant and about other things. Are they normally this humorous?
Yeah, the good ones are. You can always find some good gems out there.